So ICANN has had a process that started back in 2006, 5 years ago now, on how to introduce new GTLDs. And probably the biggest issue, certainly the most talked about issue, deals with intellectual property and trademark. And one of the questions is, how do I make sure no one applies for my GTLD if I have a trademark on that GTLD? And the second most common question is, how do I handle second level registrations within a new GTLD if I own a trademark? So starting with the first question of, how do I make sure that nobody applies for my for a new GTLD string that's my trademark? So if I'm eBay, for example, how do I make sure nobody but eBay applies for .ebay? And that's actually a relatively simple question, and one that's been worked out by the ICANN community in such a way that benefits the trademark owners. And I really don't think, given the cost of a new GTLD, of applying for a new GTLD, that those squatters, for lack of a better term, would actually apply for it. After all, if you're going to spend $185,000 just to apply, you're probably not going to be someone who's going to apply for a name that's famous and well known by someone else.
Right.
And those proceedings are pretty in depth. They're going to be carried on by dispute providers that are well known for hearing these types of domain name disputes. And frankly, given the cost, I don't really believe that that's going to be an issue. Now, some may consider it an issue if it's a trademark like United, for example, which, there's United Van Lines, there's United Airlines, there's United Financial, there's all sorts of different industries where you're allowed in the real world to own a trademark for, because it's not confusing to someone else's use. Mm-hmm. You may get United Airlines to apply, and you may have someone like United Van Lines upset about that, but that's kind of the way the real world works. And there is, for most trademarks, unless it's really famous and well known, you're going to have others that have rights to that trademark and may apply for it. The second question, with respect to, once I have a new GTLD, let's say it's a dot green or a dot, let's take a dot music. Everyone's asking the question of, how do I make sure that no one registers a dot music address that is infringing on my trademark? That's a much more complicated question, because that happens today in .com and .net, that you'll find trademarks that are being registered. There are existing procedures to deal with it. There's a uniform dispute resolution policy that deals with what's called cyber squatting, or registering a domain name in bad faith. So if I register today ebay.biz or amazon.biz or neustar.biz, and I'm not Neustar, Amazon, or eBay, there are dispute resolution policies that will handle that and will return a domain name to its rightful trademark owner if the name is being used in bad faith. The problem that many trademark owners have, and you'll see reported in a lot of press, is that if you introduce 1,000 new GTLDs, let's say the high estimates come true, trademark owners are worried about registering their domain in every single one of those namespaces in order to prevent others from doing it, which could be a fairly costly undertaking. But also, what if someone else registers it? How do I go after them if they're squatting on it? And the costs, as you can imagine, could escalate very quickly. And to that end, since 2006, there have been a number of discussions and a number of new intellectual property protections that have been introduced by ICANN into this new GTLD process that provide better protection than what exists in .com today. Those include something called the URS, which is the abbreviation standing for Uniform Rapid Suspension Policy or process, and that provides a faster, cheaper, more efficient way for trademark owners to go after domain names that are clearly being used in bad faith. There's also something called a sunrise process, or a pre-launch mechanism that's required of all new GTLDs when they launch. That ensures an opportunity, for example, for trademark owners to register their names in advance prior to it opening up to the general public. Or an IP claims, intellectual property claims process, which allows trademark owners to file a claim on any name within the domain space. And if someone during the launch process were to apply for that name, that person or that entity would get a notice back saying, look, someone else has got a claim on that name. For example, let's say your .web, and someone applies for ebay.web, and you apply for ebay.web, and eBay has filed a claim, then the person applying for that name will get a notice back saying, we've noticed you've applied for ebay.web. Please note that there is a company out there called eBay. Here's all their information. They filed a claim. If you proceed with the registration, it's pretty likely you're going to be challenged. So at least then when someone registering the name does it, before they complete the application process, they'll be put on notice of these claims that are out there, and basically register at your own risk. And so that is actually the IP claims process was introduced in .biz back in 2001. I created that process. It was something different than what had been done before, and actually it's only ever been implemented in .biz at this point. So Neustar is the only one that's actually ever done it, but it's a process that a lot of trademark owners have gotten behind for the new GTLD process, and is something that you may see introduced with new GTLDs.